Inside the Ghana Police Service, rank isn't just a title. It is literally everything. It is the lifeblood of the Ghana Police Service. When a junior officer sees a senior, they salute and they stand at attention. Respect flows upward through the hierarchy like water finding its level. It's a code written in years of tradition. But what happens when the very system designed to honor rank and service suddenly turns the code upside down? It is February 2021, and the story started with a directive from the Office of the IGP, the Inspector General of Police. The message was clear and specific. Any officer who graduated from the training school on or before December 2008 and had earned a university degree needed to submit their certificates. A special exercise was imminent. The officers obeyed and they gathered their hard-earned degrees and documents and they submitted everything and waited. 5 months passed and then the announcements began. Special administrative promotions were being rolled out. This was the IGP Special Amnesty Program. General corporals suddenly became sergeants. General sergeants jumped to inspectors with 3-point status, and inspectors rose to chief inspectors. Excitement rippled through the service. Officers celebrated and families rejoiced. It seemed like loyalty and education were being rewarded. But in every story of triumph, there are those left standing in the shadows. There was a group of officers who received something different that day. No promotions and no advancements, just congratulations. These were the chief inspectors who had already reached the maximum rank in their junior officer category. They had served longer than almost everyone who was being promoted. They had submitted their degrees as well, just like their juniors. They had followed the same directive and harbored the same hopes and expectations. And now, they watched officers they trained, officers who saluted them yesterday, suddenly become equal in rank. Something inside them broke. Their years of service had been rendered meaningless. Among them stood Christopher Okpattah, who looked around and saw his colleagues, men and women who shared his disbelief and a deep sense of betrayal. He had a choice to make. Were they going to accept this quietly and fade into bitterness or fight? They chose the latter. In a system that demands obedience, they decided to challenge the highest authority. They sued the IGP, the Police Management Board, and the Attorney General. Their demand was simple. They wanted the amnesty to be extended to them. If our juniors are moving up, move us also upwards to the Assistant Superintendent of Police status and give us what fairness demands. The IGP and the Attorney General had an answer ready, and it seemed very airtight. The law ties our hands, they argued. You can only promote up to Chief Inspector Maximum under our authority, and you are already there, and so we have no power to take you higher. The affected officers fired back with a counter-argument. They said that even if you can't promote us directly, you could recommend us for direct entry into the police academy. That pathway exists. You just chose not to explore it. Why? The case went to trial at the High Court in Kumasi. Evidence was led and arguments were made. Cross-examination revealed certain cracks in the narrative. But in February 2025, the High Court dismissed the Chief Inspector's case. The gavel came down hard and their case was dismissed. Most people would have given up. Most people would have accepted defeat. Chris Okpattah and his colleagues were not most people. He appealed to the Court of Appeal in Kumasi, retaining the representation of Diana Isian of Stellar Law Consult in Kumasi, a lawyer who understood that this wasn't just about rank, it was about equity, justice, and the very soul of fairness in public service. Her submissions were framed around these ideals. She submitted that the High Court failed to see the IGP's exercise of discretion as being fundamentally unfair and violating due process. It contradicted Article 296 of the Constitution. The court below focused only on CI 76, the police regulations, but completely ignored the special amnesty program that had existed for years. These officers submitted their certificates in good faith. They were congratulated, but congratulations without substance is just cruelty dressed in politeness. Their legitimate expectations were shattered. What remained was the pain of discrimination. The IGP and the Attorney General still stood firm. In their view, CI 76 did not give them power to promote beyond Chief Inspector. They repeated these arguments. It doesn't let us grant direct access to the police academy. Junior ranks can only cross into the senior officer territory through competitive examination or a special recommendation. Just having a degree doesn't automatically entitle anyone to promotion. To them, the law was the law. Then came a moment of tension that must have sent chills down the affected officers' spines. The Court of Appeal questioned the very procedure which they had used. Typically, challenges to public duties were done through judicial review, not by a writ, the judges noted. Had they made the fatal procedural error after years of fighting? Counsel addressed these concerns effectively. The nature of this case required evidence to be presented fully, she explained. The circumstances needed to be opened up and examined holistically. The writ was valid and necessary, and nothing in the law prohibited it. The Court of Appeal listened and were convinced, and the case proceeded. This was the signal sign of good things ahead. The judges began their own examination of the evidence, and what they found changed everything. Under cross-examination, admissions had been made, and the pleadings told a story that could not be ignored. The Special Amnesty Program existed long before the CI-76 came into force, and it continued to operate after. Yes, the court dug into CI-76 and found that promotion could happen through multiple pathways. Promotion examination, yes. Seniority and length of service with good conduct, yes. Special recommendations for bravery or outstanding performance, yes. Recommendations from the Police Appointment and Promotion Advisory Board, chaired by the IGP himself, yes. Recommendations from senior officers under whom someone serves, yes. All these pathways existed for both junior and senior ranks. The court examined who had the power to actually implement these promotions. The appointment board could promote from constable to chief inspector directly. That same board would advise the police council for promotions of officers at the rank of assistant commissioner of police and below. And the board could recommend to the council for even higher promotions to be approved by the president. Christopher Okpattah and his colleagues as chief inspectors fell squarely within the category the board could advise the police council about. The IGP's claim that his hands were tied was therefore untenable. The board clearly had a crucial role. It simply chose not to play it. Then the evidence became more damning. The IGP admitted receiving the certificates from the affected officers. This admission was critical as it eliminated any doubt about whether they had complied with the directive. On the witness stand, Chief Inspector Okpattah testified that the amnesty program had existed for a long time. Then a witness of the IGP took the stand and confirmed it. He admitted that he himself had benefited from direct entry into the police college without examination back in 2011. And then he claimed the program had ended in 2011, before CI-76 came into force. The judges must have exchanged glances in that moment, because this entire lawsuit was about an amnesty exercise carried out in 2021, almost a decade later. The claim that the program had ceased was simply also untenable. The more the Court of Appeal examined the record, the clearer the picture became. The High Court had gotten it wrong. A substantial miscarriage of justice had occurred. The rights of these 40 officers had been violated. Their career progression had been blocked. Their financial standing had been damaged. Their status and dignity within the service they had devoted their lives to had been severely diminished. And for what? The court found discrimination plain and simple. The board, chaired by the IGP, had the power to initiate the promotion of these officers by engaging the police council. Only the board could do this, and they simply did not. No explanation was offered except the claim of powerlessness, which evidence has thoroughly dismantled. The Court of Appeal had seen enough. The treatment of these officers was unjust and unfair. The police service and all its relevant bodies had a responsibility to right this wrong. The orders came down. The IGP, acting by himself and through the promotion board, but to take all the necessary steps, including making the relevant recommendations to rectify the errors and grant the officers their promotion. Timeline was 6 months. The police administration was to pay all entitlements due the affected officers retroactively from the date their junior colleagues received their amnesty promotions. And then came a final warning. The court warned against any victimization of the officers for seeking justice and equal treatment in promotion, which is simply the dream of many officers and public servants alike. On January 22nd, 2026, Christopher Okpattah and his 39 colleagues won. Perhaps the salute would mean something different now, not just deference to authority, but recognition that authority must answer to fairness. Follow Sweeper Law GH Studios for more real stories, real cases, real people.